Plaintiff, if you file an emotional distress claim, you can expect the defendant to file discovery, asking for your medical records. But there are some circumstances where the defendant's request for medical records is not warranted. And that's what we will talk about today. And additionally, the plaintiff's right to object. So when is defendant's request for plaintiff's medical records not warranted? It's when the plaintiff alleges damages for emotional harm or mental anguish without professional treatment or placing their mental condition into controversy. It's called garden variety emotional distress. It's distress that is ordinary or commonplace, distress that can be easily described, is simple or usual. In this case, Chase versus Nova Southern University makes a great distinction between garden variety emotional distress and emotional distress. Check it out. The commonplace and usual distress that we're talking about is the feeling of being humiliated, chopped down, or afraid of your boss, or a coworker for that matter. The feeling of intimidation, the feeling of being demeaned, harassed, or belittled. In other words, an individual does not need a physician, a therapist, or a professional to describe the distress that they suffered. In Cuevas versus Winworth group, for example, two brothers were terminated, and they successfully described to the court their distress without having to submit medical records. They prevailed. You need to check this one out as well. Now, where the plaintiff is alleging a garden variety emotional distress claim, the complaint must mirror that. I have provided a case below, Prado versus Equifax, cited by the American Bar Association, a good source, an excellent source. And in this case, it demonstrates what not to include in the complaint if in fact the plaintiff is alleging garden variety emotional distress. There is no separate claim for emotional distress. There is no allegation of a specific mental injury. There is no plan to offer expert testimony on the subject. And there is no plan to rely on medical records at trial. And read this case. It will definitely instruct you. Now, if the plaintiff believes in good faith that the defendant is not entitled to medical records or any discovery for that matter, the plaintiff must comply with the rules. So I provided you with the Federal Rules of Civil Procedure on how to respond and object to discovery as it relates to interrogatories, production of documents, subpoena. Otherwise, you could be faced with sanctions. Comply with the rules. I'm Advocate Lucinda, your empowerment lawyer. See you next time.